Okay, let's take a look at the judicial branch. Again, this is going to be part one of the PowerPoint covering the judicial branch. If we look at the entire unit, and again, this is just an introduction to the entire unit, we're going to be looking at three big concepts. One of which is the one we're going over today, and that's only half of it. That's over Chapter 18, what the judicial branch actually looks like. The second big concept is going to be the First Amendment rights, your RAPs, your freedom of religion, assembly, press, petition, and speech. And then finally, the third big concept in this unit is the rights of the accused, Chapter 20. If we look at the information about how the judicial branch is set up, we have what is called a dual court system. We're going to have two types of courts in the United States. One is going to be the federal courts, and you're going to have three levels. You're going to have district courts, appellate courts, and then finally way up on top is going to be the Supreme Courts. I am not looking for you to remember that there are 94 trial courts or 12 regional courts. Just understand their purpose. Understand that there are 1,700 judges when you count all the judges in all three levels, and the president is responsible for nominating any vacancies of those 1,700. But of course, the Senate has to appoint them, approve them. Now, having said that, we also have a state court system, again, that reinforces federalism. So the state courts, if you break a state law, this is where you're going to have a trial. Because there are so many states, obviously most court cases will be in state courts as opposed to the federal court system. They call that first level a little different here in Illinois. It's going to be called the circuit court, not the district court, but ultimately it's the same thing. We also have an appellate court and a Supreme Court. So that is what is meant by the dual court system. Federal court on one side and the state court on the other. There are two types of cases as well. One will be criminal court case, and that is when you've broken the law. For instance, shoplifting, kidnapping, rape, arson, bribery, assault. On the other hand, there are civil cases that are heard in civil court. That's going to be punitive damages for something, like tort cases, for instance, personal injury. There are going to be other issues such as debt collection, divorce, foreclosure, breach of contract, things like that. There are going to be two types of crimes. One is going to be misdemeanor, where things aren't as serious. What we're going to be looking at then is petty theft, public intoxication, trespass, simple assault. Now, felonies obviously are going to be much more serious. Murder, robbery, burglary, stalking, computer trespassing, rape, assault, possession of drugs with intent to distribute. This very interesting video that I wanted to show, and it is about the appointment process. As I stated earlier, please don't forget the president will appoint all openings in the federal court system, but the Senate has to confer them. So I'm going to hit this and watch this. This is pretty interesting.
For a little inside analysis on the Elena Kagan hearings, we're joined by Marcia Coyle here on the steps of the Supreme Court. Thanks for your time today.
Happy to be here.
So in terms of the nomination process, what are some of the key moments that have gotten us to where we are today?
Probably people would be surprised to learn, Hari, that judicial nominees did not appear before the Senate Judiciary Committee until the late 1950s. That's when we started having them appear and have public hearings. I would say probably the nomination of Robert Bork was the major turning point in how we have hearings today for a number of reasons. He became quite controversial because of the position he took on how he interprets the Constitution, which he felt went back to the original intent of the framers. And when he did that, he didn't find a right to privacy in the Constitution. And this ignited a lot of debate and discussion outside of the judiciary hearing room. We also saw with his nomination an intensification and intensifying a special interest group involvement in confirmation hearings. I believe it was 17 special interest groups that came to the Senate Judiciary Committee and testified against Robert Bork. And that was only inside the hearing. Outside of the hearing, there were television ads, special interest newsletters. It just generated a firestorm of controversy, his nomination.
Ted Kennedy weighed in as well.
Senator Ted Kennedy led the fight against his confirmation and had a very well-known speech in which he described Robert Bork's America.
In Robert Bork's America, there is no room at the end for blacks and no place in the Constitution for women. And in our America, there should be no seat on the Supreme Court for Robert Bork.
Of course, Bork was defeated by the Senate, and his supporters, Republicans, conservatives, coined the term, "You've been borked," in the future. If a judicial nominee of any court faced opposition, there was this concern that he'd be borked by the liberals in the Senate.
So post-Bork is when it's become a much more politicized process?
I think it was much more politicized, but also I think it was a warning shot to presidents that if they picked someone who had a paper trail or was the least bit controversial, they would find that they were facing a battle in the Senate. So we started after Bork with a series of nominees who really didn't have much of a paper trail. There were one or two exceptions, but when they got to the Senate Judiciary Committee, not that much was known about where they stood on particularly controversial legal questions that would face the Supreme Court.
When we look back at Sandra Day O'Connor's testimony, she was remarkably candid, especially about abortion.
I would like to state, first of all,
I think she was surprisingly candid about abortion when she revealed how she personally felt about abortion.
my own view in the area of abortion is that I am opposed to it as a matter of birth control or otherwise.
But that she would faithfully apply the precedents on abortion that the court had issued. But I don't think she went too far in terms of other issues. I think Bork was probably the most revealing. And then after Bork, the nominees were well schooled in saying that they couldn't comment on particular issues because those issues might come before the Supreme Court.
I have to accept, because it is precedent, that as precedent, and so I can't comment further than to say that I understand the questions.
But in this day and age, would it even be possible for a Sotomayor to have made it through the confirmation hearings had she said, here's my view on abortion?
I think it would have been very difficult. We know how controversial and divisive abortion is. And I think probably some members of the committee have a sense of where these nominees may stand on the abortion question. But you're not going to get a nominee to come out and say, I would reverse Roe versus Wade or any of the other Supreme Court precedents. They're going to pledge allegiance to what we call stare decisis, which is standing by the precedents of the court.
I have not got any agenda on what should be done with Roe v. Wade if that case were brought before me. I will listen to both sides of that case. I have not made up my mind.
How did the Clarence Thomas hearings change the tenor of hearings forever?
In 1981, I was introduced to now Judge Thomas by a mutual friend.
The Thomas hearings sort of upped the ante on partisan politics. It was an anomaly in a sense that we don't often hear senators questioning nominees for the Supreme Court about their personal lives. But with Thomas, there was a charge of sexual harassment, and it was something that reflected on his character, which is an important issue for senators in judging whether they should confirm a nominee. But it became a very bitter sort of confirmation.
There is nothing this committee, this body, or this country can do to give me my good name back. Nothing. I will not provide the rope for my own lynching or for further humiliation.
So was that the sort of watershed moment from there there onward, we've seen really a left versus right nominee versus confirmation, in the sense that we have senators who are supportive automatically throwing softballs out, and senators who are ideologically opposed just hammering the witness?
I think Fork was the watershed. I think, as I said, that Thomas upped the ante, but also was something of an anomaly. I think the senators who have share the same political party that the president does will want to support the president's nominee. Today, everything seems more highly partisan, so I don't think you can just blame Supreme Court confirmations for that. We see it on just about every issue. So do the American people see it on just about every issue that goes into the halls across the street.
But did the hearings become more personal? Did we redefine what we could start asking people about?
I don't think the ground rules have changed. I'll be very surprised if senators ask Elena Kagan if she's gay. I think that issue has come up, but it's come up because of special interest groups that are involved in this confirmation process. I think Senator Leahy, who chairs the Judiciary Committee, has said that he would rule that type of question out of order.
Marcia Coyle with the National Law Journal, thanks so much for your time.
Okay. Again, about the appointment process, how special interest groups get involved, and how contentious they've become. Clearly, anybody who works, or any judge that is in the federal court system, at least where we're studying, the 3 levels, are going to be serving for life until they resign, retire, or unless they are impeached.
Pleasure.
Sorry about that. We'll kind of do this, and then we'll click there. Financially, the Chief Justice makes about $217,000, as you know. I kind of put that in every unit. The presidents, the justice, the senators and congressmen, and Associate Supreme Court justices make about $208,000. Again, a lot of money a year, but as I reiterated with all the 2 other branches, they could be easily making a lot more money in the private sector than they would here working for the government. If you are done with this and don't have to rewind and catch up on anything, what I'd like you to do is on the right-hand side of my Honors Government page, there's a worksheet that says PMI. Do me a favor, please print that off, follow the directions, and turn that in on Tuesday morning. Have a great weekend, and I hope this causes you to have the information a little bit more accessible for the quiz and for the test.